I think it was Tina Lai who on the last panel discussed that given the challenges, geopolitical challenges, there's perhaps been no more important time to think about domestic accountability for international crimes, as imperfect as that approach is. And so I wanted to ask you, I mean, first, could you just briefly explain for the audience what the principle of complementarity is and how important it is for the court to do work to encourage and galvanize domestic prosecutions of international crimes?
I mean, in the simplest terms possible, the principle of complementarity dictates that the ICC is a secondary court. As in, we kick in when there is a gap at the domestic level or there is a failure at the domestic level. I remember the first prosecutor of the ICC, Luis Moreno Campo, when I had just started working there, he said, the ICC would succeed if all cases were handled at the domestic level and no cases came to the ICC. That, of course, that's an ideal vision, but that is the principle of complementarity, that the ICC is a secondary court and that the entire international justice system encourages and ideally would prefer domestic proceedings. And the ICC is only there as a stopgap. And I think if you read the policy from last year, what you'll see is that same concept viewed not only as a negative, but also as a positive, as in the ICC isn't just waiting to see whether someone is going to do something downstairs. The ICC is going to actively help and work with domestic actors, civil society actors, and regional actors. That's the idea.
So when the policy came out, I think many people are excited. My colleague Michael Delagrange basically got on the phone and told us, a new J.K. Rowling book is out. We need to read it. He was so excited. He thought it was, the flashiest, coolest thing you could read. And certainly for those of us who read it and work in these spaces, it is a rather incredible document that suggests an important shift or a series of shifts in the thinking of the Office of the Prosecutor. Could you tell us a little bit about what is new in the policy?
Right. I mean, at a basic level, of course, the principle of complementarity has always been there, and we've always respected it as part of the statute. I think what's new is a renewed desire to assist with domestic proceedings and to engage with domestic proceedings in a proactive kind of way. If you think of the various proposals made in the policy, the idea of building communities of practice, the idea of using technology as an accelerant, the idea of becoming closer to victim communities, all of this is, I think, in all humility, a recognition of the limitations of the ICC and the realization that we need to do as much as possible to help domestic proceedings as well. And then that is the sort of bird's eye view of what's new, I think. And then much of the policy is about breaking down how we can do that. The types of fora that can be used, and the types of mechanisms that can be used. And we can get into the weeds as and when you like.
Yeah, let's do that. Let's get into the weeds. So we have a number of civil society organizations here working on Sudan and elsewhere. So how could this new policy on complementarity speak to them as actors engaged in documenting international crimes and pushing, as we've seen so inspiringly, for accountability in Sudan?
So I'll begin by saying we really shouldn't look at domestic accountability and international accountability as a competition. We're not working against each other. We're not fighting each other for cases. That's not how the ICC views it, and I certainly don't think that's how any domestic accountability actor should view it as well. I think we should view ourselves as all being on a spectrum. You have domestic criminal proceedings, domestic civil proceedings, accountability mechanisms like the FFM, CSO civil society organizations who assist these other proceedings, as well as international and regional criminal mechanisms. And I think a really useful lesson or a really useful takeaway for civil society organizations is that you, as accountability actors, can feed into all parts of this spectrum. You know, if we think, for example, of a civil society organization documenting an attack on a village. Okay. You can talk to victims, you can take photos of what happened, and you may well want to use it for multiple purposes. You can use it for advocacy, but at the same time, if you follow appropriate methodology, you can also use it as record keeping of criminality. And then your product could be used by a domestic mechanism, like the War Crimes Division in Uganda, like all sorts of places. It can also be provided to bodies like the FFM, as described by His Excellency this morning. And you can also provide the same data to the ICC. So in a way, there are many different options for how this setup can be used. And in the same way, you can use the ICC as a source of resources. Now, I don't mean resources directly in terms of funding, but for example, the ICC has decades of experience in terms of developing protocols for information security, developing protocols for evidence storage, collecting open source evidence about, let's say, attacks in crimes in Sudan. Now, all of those things are potentially useful for a civil society organization that's working on accountability. And I know this because I have worked with civil society organizations, and we have tried to share this kind of data. So those are a few of the options available.
So, excuse me, on that note, so are there any potential obstacles or challenges in sharing that information with civil society, and how could those be overcome? Because I'm sure there are people here doing work on justice and accountability who would be keen to have a relationship where evidence or at least information could be shared.
Right. So there's two kinds of challenges. One is a subject matter related challenge. The ICC will find it very difficult to share witness statements, because when we do an interview, we go through all kinds of make all kinds of promises relating to confidentiality, which then become difficult to deal with. I'm not saying it's an impossibility. I'm saying it's hard. So it may be easier for the ICC to share open source information as well as information related to best practices. The other challenge, I think, is how to keep this conversation going. And we had a chat about this briefly, Mark, before we started. One of the challenges is, let's say, me or someone from my team, we will often go to consultations of this nature. We will have a very useful conversation with a civil society activist or the head of a civil society organization, make very promising agreements, then we all go back to our offices and we're all sidetracked by the other work, and that relationship never actually triggers into something, a regular exchange of information. So that's also a challenge. And that's why I think we can have very useful conversations about what can civil society organizations do as a link between international criminal mechanisms and activists working on the ground, and I'm sure we can talk more about that.
Did you have any civil society organizations in mind? Perhaps the Wayamo Foundation. I mean, Wayamo has for a long time, since its inception, sought to do the work of complementarity. That's the space in which the organization seeks to translate information from the court to the local and from the local back up to the court, to operate as that kind of translator or that link. So in this space of complementarity, and perhaps especially with respect to the situation in Sudan, what role do you think Wayamo or an organization like Wayamo could play?
Right. And I'll say Wayamo or organizations like Wayamo because, of course, I'm sure it it's something that a number of CSOs can work on.
Only Wayamo.
Only Wayamo. Very good. So I think that, I'll give you an example. Let's say there's accountability activists working in Central Darfur, or South Darfur, or West Darfur, and they have leads, they have information, photographs, USB files, etc. They, while they are very close to the ground, have no links to the international criminal investigative world. But then there are organizations like Wayamo which are building communities of practice, which are doing capacity building, where you will have contacts, names, ways of communicating securely, and at the same time, a CSO like Wayamo, you have links to the ICC, you have links to the UNFFM. So I think if there was a way of maintaining a regular flow of information, and I think the key here is regular, doesn't mean every 6 months we meet up in Kampala. If there was a regular way of sharing information up and down, I think that would be very helpful. It would be helpful for people like me, and I think it would also be helpful for people working in accountability in the context of Sudan, because we share the same goals. It's just that we may not know each other well enough or have enough contact with each other to do operations well.
I think that's an incredibly useful thing for all of us to know and to take on board. When we're thinking about complementarity, we're typically thinking about, especially in recent years, the ICC and its relationship with the state in which the crimes were committed, right? That's historically the way that we think about it. But in the context of Sudan, of course, that isn't how we should be thinking about complementarity, because the Sudanese justice system is either incapable or unwilling to address international crimes committed both historically in Darfur, but also, of course, more recently. And so one of the things that we've discussed, and that keeps on coming up, and rightfully so, is the question of universal jurisdiction. And so how do you envisage this new complementarity policy and the numerous actors that we have in the room, whether it's Sudanese civil society advocates, journalists, Wayamo, et cetera, in working with this policy and working with the court in order to foster, for example, cases relating to universal jurisdiction?
Right. I mean, I'm a huge fan of universal jurisdiction. I mean, if it was up to me, the ICC would have jurisdiction over whatever number of countries there are in the world, and universal jurisdiction would work equally well in all countries. Of course, we know that's not true, but if there's one takeaway I took from the previous panel, is that there are opportunities, right? And I certainly don't think we should limit ourselves to thinking that, you know, complementarity is only a relationship between the ICC and the situation country. That's definitely not how we view it. Even if you look at the joint investigative teams that the ICC belongs to in the context of Libya and in the context of Ukraine, we are clearly more than willing to work with multiple countries, any country which is interested in carrying out accountability work. So in the same vein, if any country is interested, or any domestic judicial authority is interested in working on Sudan, we would be more than willing to build a relationship there. And there again, I don't think it's, and it can't just be a state ICC relationship. I think that civil society is going to be really the engine that drives that relationship. Because you also have to realize some states are very interested in UJ, and some states are very not, you know. But enough activism and enough advocacy, and almost any state could be brought to the point where they would assist in UJ activities, you know.
So you mentioned that in relation to UJ and these types of cases, that civil society will really be in the kind of driver's seat. But one of the, or I should say and, maybe not but and one of the interesting things about the complementarity policy, the new complementarity policy, is that it speaks to a court that would be more proactive with sharing information. And I wanted to ask you, has the court been proactive in offering civil society or other relevant actors information that would help them in building their own cases or understanding certain events? Have there been efforts to be more, as I said, proactive? And what does that look like?
Sure. I think in the early days, before I worked on Sudan, I worked on cases relating to Uganda. And back in the day, we liaised with Ugandan prosecutors, for example, to share lessons and share experiences, and especially in the context of international humanitarian law, because there were a number of challenges at the domestic level back in the early days of the Coelho case, for example. So in the early days, it was a state ICC relationship, but now we have, I think in recent years, expanded that experience. Certainly speaking for work on Sudan, on Darfur, my team has liaised with multiple activists and organizations working on accountability, especially in the context of, okay, what are best practices for carrying out investigative work? What are best practices for saving leads in your organization's computer? What are best practices for sharing information between you and another organization? Because I think one of the things a lot of CSOs are interested in is usability of their collected data, right? Because of course, if you're a CSO working in accountability, you want to collect information that is useful and will be used by other organizations. So there we can talk about what kind of information will survive admissibility in a court case. Should you be interviewing witnesses if you want those witnesses to testify in a criminal trial somewhere else? What kind of questions should you be asking? So all of those things are types of information that we have shared with individual CSOs. Obviously, I can't name CSOs, but that's something that we certainly want to do in the future as well.
This is a related question, although you've already touched on it. I know many people here have either been trained on or are working on or are interested in expanding their work on the collection of open source evidence. Wayamo does that work too in training people on how to collect it, store it, verify it, etc. How does the complementarity policy speak to that and to this growing use of open source information and evidence?
Right. So if you read the complementarity policy, there'll be a section called technology as an accelerant, and I asked myself what that meant. But this is one of those areas where if you think of investigations we did 10 years ago, and if you think of investigations we did 20 years ago, open source evidence was a much, much smaller part of our evidence. And now, certainly for at least certain investigations, open source evidence is a huge part. And that what we can do is we can work on searching through, for example, if you have 1,000 videos, it's almost impossible for a small accountability organization to search through every second of those 1,000 videos. But those are things we can help with, or those are things we can provide technology that can help with. Also, if you want to trace back, if you have one open source video or photograph, and you want to check when was the original first uploaded onto the internet, that's something we can help with. If you have an open source photograph, and you want to figure out where was this photograph taken, what time of day this photograph was taken, and you don't have technology available for that, we can try to connect you with the people who can help with that. So these are, of course, very micro, very practical things, but I find that in day-to-day life, these things become very helpful.
Yeah, I think that's really useful, and I hope those of you who are interested in doing that or need those resources are able to avail yourselves of those the linkages or the networking that can happen through the court. I think that's really important and really quite new, right? This support or the potential to support and connect people and different actors. In the last panel, Adejoke spoke to the possibility that when you're confronted with an inability to go after particular kinds of perpetrators, individuals, right, the bread and butter of international criminal law, you don't have to stop there. There are companies, there are banks, and the complementarity policy speaks to the fact that, of course, when the ICC investigates a situation, it collects, like a bit of a vacuum, different kinds of information, some of which may not be directly relevant to simply holding perpetrators to account, but other kinds of evidence that can potentially be shared. Can you speak to that?
Right. I mean, definitely one category is open source evidence because there are no confidentiality measures related to those. It may well be that other kinds of electronic data could also be shared. Analytical products could also be shared. For example, if you collect large amounts of data relating to, let's say, phone records, let's say social media, etc., and if the ICC produces analytical products, then those could also potentially be shared. And in the same way, for example, the ICC, when we start working on a particular investigation, we do what is called a crime pattern analysis. That's how we decide where are the most serious crimes, and therefore where should we start first. Those sorts of products could also be potentially shared with domestic actors, including domestic actors who are not working on criminal cases. Let's say we are investigating persons who have committed crimes or who have allegedly committed crimes. You may be investigating a company in which this person works. You may be investigating a bank in which this person works, or a state organization. So there again, we may be doing slightly different things, but we may be able to use very similar evidence and share both, well, forwards and backwards. Yeah.
I think this is worthwhile emphasizing, that the court may have information that indicates that a perpetrator of international crime is engaged in money laundering or a transnational organized crime, perhaps the unlawful sale of gold across a border or oil across a border. And so to be suggestive of the next panel, there are ways in which to now think about this complementarity policy in a way that would foster the possibility to disrupt perpetrators of international crimes. And I think that that's also somewhat new, the ability to share different kinds of evidence of those types of conduct that are linked to the perpetration of international crimes. So I'll leave you with one last question. It's 5 years from now. Maybe a certain president isn't in power, hopefully, but it's 5 years from now. The court's not under attack. It's a best case scenario for you and the ICC. How do you see the ICC's relationship vis-a-vis complementarity and the situation in Sudan and elsewhere in the world?
I mean, hopefully in 5 years, both the ICC and domestic authorities will have made more progress. I'm hoping to see ICC trials. I'm also hoping to see domestic trials under universal jurisdiction. And I'm hoping that at that time there's a rich connection and an extensive sharing of information between these international proceedings and these domestic proceedings, with linking organizations in the middle, such as well-known organizations like Wayamo. but that's the kind of relationship I'm hoping for, and that relationship can exist at the investigative phase, but that relationship can also exist while trials are going on, or even after trials have gone on, when we're trying to figure out reparations. You know, so that's a long-term relationship that I think we can foster in places like this.
I love that vision, and I hope in 5 years we're sitting here and talking about how we got it done. But for now, thank you very much, Pubudu. That was excellent. Thank you.